In a dramatic turn of events, a petition challenging Vice President's dismissal of the impeachment motion against Chief Justice of India has been withdrawn by Congress. The petition was moved by 2 Congress MPs and was withdrawn after the bench refused to give the copy of the order constituting the bench itself. Arguing on behalf of the petitioners, Kapil Sibal challenged the process under which the matter had been referred to the 5-judge Constitution bench and its decision to list the matter directly.
7 सवाल कोर्ट के सामने रखे, वो अंग्रेजी में है तो मैं पढ़ दूंगा। पहला, under Article 145(3) of the Constitution, if it appears to the Supreme Court that a substantial question of law as to the interpretation of the Constitution arises in any case, then the minimum number of judges required to adjudicate on that issue is prescribed under the Constitution to be 5. Dusra, reference to 5 judges can only be made by a judicial order. The rules of the Supreme Court do not allow the Chief Justice of India to pass an administrative order to refer a matter to 5 judges on the ground that a substantial question of law as to the interpretation of the Constitution arises in the case. 3. In the present case, there is no judicial order formulating the substantial question of law involving the interpretation of the Constitution, which is required to be adjudicated upon by a Constitution bench. 4. It is assumed, since the petitioners are not privy to any such order, that the concerned authority took the decision that the issues raised in the petition are required to be adjudicated upon by 5 distinguished judges after due application of mind on the issues raised in the petition. The petitioners are entitled to know the authority who on the administrative side passed an order to refer this matter to 5 distinguished judges. 5. If the authority happens to be the Chief Justice of India, against whom a motion of removal on the basis of certain articles of charge was filed and dismissed by the chairman in exercise of powers under Section 3(1)(b) of the Judges Inquiry Act 1968, then the petitioners are entitled to be informed of the order and contend that a copy of the order be furnished to the petitioners before any proceedings take place. 6. If that order has been passed by the Chief Justice of India, constituting the bench, then the petitioners seek to challenge the order on such grounds as the petitioners may deem fit. And last, it would be inappropriate for the petitioners to seek any indulgence of this court on the merits of the case till such time as such opportunity is afforded to the petitioners.
Mr. Sibal, appearing for the petitioners, for the MPs who had challenged the Vice President's order, he said that, look, we need to know as to how this matter has come to be listed straight away before a Constitution bench. It has never happened before that a matter or a writ petition which is filed is listed before a Constitution bench even without a judicial order. And we need to know if the Chief Justice has passed this order. And if the Chief Justice has passed this order, what are the grounds? We need to have a look at that order so that we can challenge this order, because it's an administrative order of the Chief Justice, and every administrative order of any authority, even if it is of the Chief Justice, is capable of being challenged on the judicial side. Unfortunately, the bench said that no, they would not like to go into this question, they would not like to provide a copy of the order, and they would like to hear this matter. At which point of time Mr. Sibal said that, look, if you are not even giving us a copy of the order and an opportunity to challenge the order, if we want to challenge of that administrative order of listing it before a Constitution bench in Court 6, then please allow us to withdraw the petition. And thereafter the petition was withdrawn.
So after the Congress withdrew its petition, Finance Minister Arun Jaitley launched a scathing attack on Congress's attempt to impeach the CJI. Arun Jaitley said that the motion was wholly misconceived, lacked substance and was poorly drafted. He also further said that the plea challenging Vice President's order was unarguably Congress fishing in troubled waters.